Hey y'all, it's Trish with Arch Legacy Firm. Happy Wednesday, and thank you for joining me for Whiskey and Wills. So in our last video, we talked about wills, what they do and don't do, and the probate process here in Georgia. And just as a reminder, wills do not avoid probate. They're actually just legal directives that tell the judge what you want to happen during probate. And in Georgia, the probate process typically takes anywhere from 6 to 12 months. Maybe a little bit longer post-COVID, and it is a court process. There are attorney's fees, and it is a pretty stressful, drawn-out, and expensive process. So I think I mentioned in the last video that the way for families to avoid probate for their loved ones is to actually create a living trust. And I'm here to explain a little bit more about what a living trust actually is, and try and shed some light on something that not a lot of people have heard of, although we're trying to change that. So cheers. I'll go ahead and jump right into it. So living trust. A living trust is basically just a mechanism, a bucket that holds all of your assets for you while you are still alive. So a living trust, the full name is a revocable living trust, really has not a whole lot in common with what we think of when we think of trust. We think of trust like trust fund kids who inherit millions of dollars from their grandparents, or these irrevocable trusts that are used as asset protection trusts or estate tax planning trusts. A living trust is literally just a probate avoidance tool. So it's no asset protection or anything like that. And really, its only goal is to avoid probate. And it's a really important goal because probate kind of sucks, frankly. And I've never met someone that was like, oh yeah, probate, it was easy peasy, no problem whatsoever. Just totally an enjoyable process. No, it is a court process. Your family will have to hire attorneys. They will cost a good amount of money. And it is a long, drawn-out process. So what a living trust does is we title things legally into the name of the living trust versus as you independently. So instead of your house being owned by Sam and Sally Smith, your house will be owned as Sam and Sally Smith, trustees of the Smith Family Living Trust, dated blah, blah, blah. And what this does is that after you pass away, instead of your house having to go through probate for your kids, or even sometimes your spouse, depends on how your house is titled, then your successor trustee that you've named can immediately step in and do whatever they need to do with your house. So whether it's keep it and pass it on to one of your adult children, or if you have minor children, your guardians are moving in, or if it's just getting it ready to sell and selling it. This is so much more preferable than this having to go through probate, because if your house has to go through probate, it's going to be there for a while, and your family or the executor is going to have to pay these costs out of pocket until the judge signs off on it and they get to sell the house, or they have access to your bank accounts and assets. So again, really, really important with things like your house. The other things that you would want to move into a living trust would be your bank accounts, investment accounts, things like that. And it's a huge benefit for these because not only now does a successor trustee immediately get to step in and have access, now they also can be an incapacity trustee. So what is that? What exactly does that mean? Well, with all of our estate plans, we want to make sure that not only are your kids provided for after you pass away, or your family, we want to make sure that you're taken care of during incapacity. So with incapacity, for example, because it is what it is, we're in the middle of COVID. If you have COVID and you're on a ventilator, you probably cannot be paying your taxes yourself at that point, or paying your mortgage or your bills or making healthcare decisions. So you need to designate people that you trust and want to do this for you. So we do power of attorneys and healthcare power of attorneys, and those are very, very important documents. But a living trust goes one step further and actually names an incapacity trustee as well. banks, financial institutions don't love working with power of attorneys anymore because there's a lot of fraud and liability involved with that. So if someone walks into the bank with a certificate of trust and a power of attorney, they're just a lot more likely that the bank is going to work with them a lot sooner and quicker off the bat versus having to go through a lot more hurdles to get access to bank accounts. So, and obviously we want, again, our goal is to make sure that you're provided for, your life is taken care of if you're not able to, or when you're gone, that this can be cleared up as quickly as possible. I've seen what probate can do to families. My dad was in probate for 4 years after the passing of my grandfather, and it was miserable. And 6 years later, there's still things being found. So one of my goals when I work with families is to make sure that when they pass away, their family can grieve and have this process be as stress-free and quick as possible. Now, it's never a very easy process, especially if you have minor children, but a living trust is going to make it light years easier than if you just have a will alone, because of course our goal is to make it so that there is no judge and no court involved. So again, a living trust, a revocable living trust, is literally just a mechanism that holds your assets for you while you're still living. While you're still living, you are the grantor, the trustee, and the beneficiary, meaning that you still have access to all of these items, your house, your bank accounts, investment accounts. You can still sell, buy, change, add, do whatever you need to do. And it's not going to change the way you're taxed either. A living trust is identified with your social security number, not a tax identification number. Unlike what some banks seem to think. Trust me, banks are always fun to work with, but we get it done. And one of the most important things about a living trust to remember is that no matter how well the documents are drafted, it does have to be funded, which all that means is that your assets do need to be moved into the trust. And I work really closely with my clients to make sure that happens, because if it doesn't, everything's going to still go through probate. So I want to make sure that my clients' plans are exactly where they need to be, and that everything is titled in the name of the trust so that their family does get to avoid probate after you pass away. Now, if your kids are younger and they're minors, one of the huge benefits of a living trust is that everything would just flow directly into the trust if both of you passed away, if both parents passed away, and you don't have to worry about minor children inheriting assets, because the fact of the matter is that minor children cannot inherit assets. So if you passed away and did not have a living trust and you had your kids on your life insurance policy or your retirement account as contingent beneficiaries, or if you didn't name contingent beneficiaries, then all of this money would flow into probate and the judge would appoint a financial conservator to oversee it. And this is a really big deal because financial conservators take about a 3% cut. The judge can appoint whoever they want to appoint. And then when your children turn 18, they just get a lump sum check. And y'all, I don't know about y'all, but I would not have trusted myself to inherit a lump sum of money at 18. I went to the University of Georgia. I had a lot of fun at the bars in downtown Athens. And, there aren't many 18-year-olds that are ready to be financially savvy. So, especially if their parents are gone. So we really want to avoid that with minor children, and living trusts are a great way to do that. All the money flows into the living trust, and then you get to be as creative as you want. And y'all, you can be so creative with living trusts about how you want your children to inherit. Do you want to do a lifetime asset protection trust where their inheritance stays in a protected trust their entire life or until they take it all out? It keeps it separate from marital property in case they get a divorce, because we hear it all the time. I love my son-in-law, but I don't want them to inherit money if they get a divorce. Or if something happens to my child, I want all the money to go to my grandkids. So this is a great tool for doing that. Also, if they're in a car accident, all that money stays protected. Or if you want to just do what's kind of included in the living trust, you, instead of a set age where they get it all just automatically, we could do a third at 25, a third at 30, a remainder at 35, or whatever ages and stages you want to do. And so there's a lot of creativity, there's a lot of flexibility. Trusts are really a great tool for making sure that your wishes really get taken care of if and when you pass away. Y'all, there's one truth in life, and it is that we do all eventually pass away. And if you have any assets to your name, it's super important to take care of this for your family if you want to make it as easy as possible for them. Because when they're grieving, the last thing they're going to do is have to figure all this out. And if we can work together, get a plan in place that makes it as easy as possible for them, you really are giving them one of the greatest gifts. So cheers, everybody. If you have any questions about living trust, please don't hesitate to schedule a free consult with me. You can go to my website at www.archlegacyfirm.com/schedule to schedule a free consult with me. I'm happy to chat with anybody. Cheers, and I hope you all have a wonderful day and a great rest of your week.